They say, as goes California, thus goes the nation. I don't know how true that is in reality, but I certainly have seen it in the past.
Originating from deep inside the Rocky Mountains, transported through the power of the internet, and arriving inside your tiny earbuds. It's the Appraiser Coach Podcast, helping appraisers increase their efficiency, quality, and make more money. Here's the guy who makes it his life's mission to create value for real estate appraisers nationwide. Your host and the Appraiser Coach, Dustin Harris.
Welcome back to the Appraiser Coach Podcast. I'm Dustin Harris, the host of this and every episode of the Appraiser Coach Podcast. All right, maybe I'm making a little lighthearted airtime for my good friend Blaine Fine. You know, if Blaine and I weren't friends, that might come across as offensive. He knows it wasn't meant that way. I love you, man. I love listening to your pod. By the way, folks, if you're not listening to the Real Value Podcast with Blaine Fine, what are you doing? Get off your duff, subscribe. A great guy, great podcast. Anyway, hey, folks, I want to talk today about this deal going on in California. Assembly Bill number 5. The big change with the contractor. It's not really a change, it's a clarification, but I'll tell you, there are some interesting things for appraisers in here. Can't wait to tell you about them. Want to first pause, remind you, we, of course, are sponsored by 3 great companies, one of them being DataMaster. I've been good friends with the people over at DataMaster for quite a while, and not just impressed with them as individuals, but also impressed with them as a company and what they can do for appraisers. Check them out. Go to datamasterusa.com. Of course, a la mode is the software that I use on a daily, regular basis to help me with my appraisal work, to help me be more efficient, more effective at what I do. Go to alamode.com or 800 Alamode. Finally, we are sponsored by Working RE Magazine. You know, Working RE is there with the backs of appraisers, helping you to be in the know as far as what's going on in the appraisal world. Check it out. Go to workingre.com. Again, it's workingre.com. All right, folks, I have in front of me, in my sticky little fingers, a memo from the Employment Development Department in Sacramento, California. December 13th, 2019 is this letter's date. Yes, it's been a couple of months. But this came to me because I have had in the past employees in the state of California. These were long-distance employees, individuals that I had employed over what you would call a virtual assistant program. No, they were not contractors. They were actually regular W-4 employees. But this particular memo has to do with Assembly Bill number 5. Now, if you have not heard of this, and you may not know it by name, but this is the bill that was passed that went into effect on January 1st, 2020. And this essentially really boiled down in very clear and unmistakable, there's no gray in this, folks, what a contractor can be and what an employee can be. Now, I know contractors are employees too, but we're talking about the difference between, when I say employee today, I'm talking about W-4 employees, okay? And I might even determine or make that determination as I talk through here. But I want to kind of make a clarification as to what contractors are. So contractors are going to be W-9. Okay, that's the form you would fill out. Many of you are familiar because you're appraisers, and if you're doing work for AMCs, you've filled one of these things out multiple times. Okay, a W-9 basically says, hey, I'm an independent contractor. I'm working for you, but not with you, basically, right? And then a W-4, of course, is much different. Well, slightly different in the sense that they own you, if you will. You are an employee of them. By the way, I'm seeing lately, and it may be because of this or similar legislation that is coming down across the country, I've seen AMCs in the last couple of years, some of them actually want you to sign up as an employee, okay, as a W-4 employee. Now, there's some, shall we say, perilous thin ice with that as well. But today we're talking about this law in California. Now, before you tune out, before you say, Dustin, I don't live in California, I have no employees in California, I don't work in California, Why does this have anything to do with me? Okay, let's start there. And then we'll talk about what this really is, what this legislation is, and how it affects appraisers. Okay, I would not tune out yet. Just because you do not live in California, just because, by the way, as a side note, I saw a note the other day, very interesting, that the number of appraisers in the last couple of years in California has been reduced dramatically. I mean, we're talking by tens of thousands. Absolutely amazing over the last couple of years. On the other hand, the applications for new appraisers to jump into this field is skyrocketing. I think 76% is up 76% this last year. Now, don't quote me on those numbers. I'm going off of memory. Totally side note. Wasn't planning on talking about that, but super interesting. Okay. All right. Back to the topic at hand. As we talk about contractors, we talk about employees, we talk about the state of California. If you are one that does not live in California, does not work in California, okay, does not deal in California, this still may affect you. And you need to be very, very careful. And yes, this does. I'll tell you this much. It's worth listening to the episode to the end today. Okay. If you are an appraiser, there is reason to believe that this law, I don't care if you live in Idaho, Florida, or Iowa, may have an effect on you long term. Okay. All right. Let's step back for just, but in fact, before we do that, let me just define why. Okay. And this will make more sense as we get into the topic today. But the reason this may affect you is at least in one memo that I received from a large AMC recently. Even if you don't live in California, even if you don't appraise in California, if the employer, okay, in this case, the AMC is located in California, okay? And by the way, how many of you actually know where the companies are based that you work for? I don't sit and look at the state that they're, I mean, I might know a few of them. There's a lot for whatever reason back in Pennsylvania. And I think that stems from a very large AMC years ago, LSI, who broke off into about 1,000 different chunks, and they're still kind of based in that same little area. But how many of you actually know where your employers are, your clients, if you will? If they're in the state of California, this may affect you. Furthermore, if any of your borrowers, for example, maybe have ties to California as an investment situation. For example, I appraise in some high-end areas such as Jackson Hole, Wyoming, right? And it is very common for somebody who lives in California to have a second home in Jackson Hole. There are direct flights. They often spend weeks out of the year in Jackson Hole, whether it be in summer or whether it be the ski season in winter. And it is very, very common that the borrower, in this case, may live in California as well. Now, how much sway does Assembly Bill number 5 have in that situation? Well, it's enough that at least one big AMC is saying, hey, this may affect you. Now, you're going to find a common theme today as we talk through Assembly Bill 5. The common theme is, and I will just start out by saying I am not a lawyer, okay? A lot of the stuff is written in legalese that I don't understand. And furthermore, a lot of this is untested because it's new legislation. Now, certainly it's based on old legislation, and we'll get into that in just a second. But essentially, Assembly Bill number 5, which went into effect and became a law January 1, 2020, essentially is a law that is untested. It is a law that we don't know how this will affect appraisers. And so I would say at the very least, at the very minimum, appraisers need to be vigilant. You need to know what this law is, how it can potentially affect you, and you need to tread lightly. Because until somebody is the guinea pig, until somebody steps on that thin ice and falls through, none of us really know how this is going to affect us. And thus, I would say that you need to lean on the side of caution. Now, I'm going to go down two roads today. One of the roads is as an appraiser, and the other road is going to be as an appraiser business owner, those that might hire others. Because this law may affect you from both aspects. All right, Dustin, what is the law? All right, let's deal directly with the law itself. And I want to start this by laying a foundation. And the foundation basically says that as an employer, okay, and I've taught for years, the 3 legs to a strong appraisal business is going to be number 1, technology, number 2, human resources, and number 3, the systems to put all of that together. Now, with leg number 2, which by the way is the strongest leg of all 3, with leg number 2 comes the ability as an employer, as somebody who needs help, you need to decide what it is that you're going to do with regard to hiring. Now, what I mean by that, again, this goes back to something you've heard me talk about many times on this program. It's the doctor's office analogy, the fact that you might go to the doctor's office and spend 2 hours at the doctor's office, but 10 minutes with the doctor. And this idea that as an appraiser business owner, you need to see yourself as a professional. Certainly, you're not making life and death situations, or decisions rather, although I did have a borrower once tell me that if they didn't get this loan, that their child would die because she couldn't get the cancer treatments that she needed. But other than that, we're not dealing with life and death situations for the most part, but we are dealing with some huge investments. We're talking about people's homes. We're talking about mortgages that are worth hundreds of thousands of dollars, sometimes millions of dollars. So it's a big deal what we do. That being said, I'm a big advocate, obviously, of focusing, concentrating on where you're needed most, right? You're the doctor. The most important part of that 2-hour visit is the 10 minutes with the doctor. And the most important part of the appraisal process should be the process that the appraiser spends the time on. And a lot of you say, well, that's the majority of it, right, Dustin? Well, maybe you should look a little bit at my website, theappraisercoach.com, take a few webinars and know that I take a different approach to that. Okay, right, wrong, or indifferent, that's the direction I go. And I spend a lot of time in my business dealing with management of people, human resources. I am a big believer in the law of delegation. I'm a big believer that an appraiser is actually a better appraiser when they delegate, because now they focus on what's more important. Think about this for a second. If the doctor was out taking your blood pressure, could the doctor be spending time diagnosing you? Well, the answer is yes, he could. But is he going to be the most effective doctor if he's spending time checking you in and taking your blood pressure and your weight and everything else that's in the realm of a doctor's office visit? And the answer, I think, is a definitive no. The doctor should focus on where she is most effective, right? And that is the diagnosis, the prognosis, the prescriptions, and everything else that comes with that. And I'm the same in my belief that an appraiser should focus on where she is most effective, which is in the valuation side, the analysis side, right? Not the data entry, not the data collection, not the answering the phones and setting up appointments, okay? So with that, whenever I hire an individual, I've got to go through this process of deciding as an employer, now, do I put this employee in the realm of a typical employee, again, a W-4 employee, or do I put this in the realm of a contractor, a W-9? Now, for any of you who've been through this process or you've been coached by me, I will encourage you to always go to Google and type in contractor versus employee, and pull up the IRS document that basically gives the half dozen tests that you need to go through to ask yourself what a contractor is. Now, let's make it very clear. The reason you go contractor, for the most part, is tax savings, right? You go contractor or W-9 because there are certain taxes that you're not going to be responsible for as an employer if you go that route. And that's why employers like to go that route. That's why when you come working for me, I might have a couple of different paths for you, and you're going to get a higher percentage as a contractor than you would as an employee, because I understand that that tax liability is now passed onto you and onto your shoulders. Okay? So that's the benefit, and that's why the IRS is so picky about who you can call a contractor, because guess what? They want their money, right? And they don't like employers going the route of contractor unless it is a clear-cut, black and white individual basis where it can be justified. Now, the problem with this in the past historically has been that the IRS's own definitions are not black and white. In other words, yes, there's a half dozen tests that you go through, but ask any accountant, ask any lawyer, and by the way, I'm neither, did I stress that earlier? And they will tell you that it's not that you have to meet each and every test, it's that when you get to the audit situation where an IRS employee is looking at you and saying, okay, Dustin, you've had Jane under your employee the last 3 years, and you've called her a contractor, but you know what, I'm looking through the tests, and I would say that you meet some of these, but not all of them. And I don't even think you meet the majority of them. Therefore, I think that you're trying to skirt taxes, and we're going to nail you. So you have to be very careful as an employer when you decide that you're going to hire a contractor versus an employee. Now, again, I want to make this very clear. In the past, it's been somewhat gray. And it really, in my opinion, comes down to that IRS audit and that individual performing that audit and that individual, what they had for breakfast, and if it's a Tuesday, as Tim would say. Okay? In other words, one might go one way and another auditor might go a different way. But it's not black and white, and that's the concern. When you hire a contractor, let's say you live in the state of Kansas, okay, so you're not necessarily affected by this particular legislation that we're talking about today, which is only in the state of California. The idea that you hire a contractor comes with a certain risk. And you've got to basically prove or at least show support for why you hired this individual and called them a contractor, and it's basically you against them. And if they say, yeah, I mean, I see where you're coming from, they wouldn't say it this way, of course. I see where you're coming from, but nah, I see it differently. Then you're in trouble. What this legislation in the state of California has done is basically taken some of those tests, 3 of them specifically, and made them absolutely ironclad, black and white. There's no wiggle room. Now, let me read to you directly from the memo that's sitting in front of me. Okay? In 2018, the California Supreme Court adopted the, quote, ABC test in Dynamics versus Superior Court. Under the ABC test, a worker is considered an employee and not an independent contractor unless the hiring entity, so the employer, can demonstrate that it meets all 3 of the following requirements. By the way, all 3 is bolded. Number 1, the individual is free from control and direction of the hiring entity in connection with the performance of work, both under the contract for the performance of the work and in fact. Okay, so let me just boil that down. Number 1 is you cannot in almost any degree be controlled or directed from your employer. Okay, so I'm going to give you a hypothetical. I don't know whether this would stand or not stand, but if I hired a contractor in the state of California and I said, I need you to go to this appointment at 12 o'clock noon on Friday, I may be in violation. I need you to wear professional clothes, I may be in violation. I need you to come to a staff meeting on Monday at 10, I may be in violation. Okay, number 2, the individual performs work that is outside the usual course of the hiring entity's business. Okay, now notice that. It doesn't say can perform work outside the usual course of the hiring entity's business. It says the individual performs work. In other words, if you are working specifically as a quote-unquote contractor for a specific company, you may be in violation. And number 3, the individual is customarily engaged in an independently established trade, occupation, or business of the same nature as the involved in the work performed. In other words, okay, on 2 and 3, I think appraisers from a contractor standpoint are pretty safe. In other words, most appraisers do not work for just one AMC. And most appraisers do work outside of that one AMC. So we're pretty safe. Where we may need to worry just a bit if we do any work in the state of California is number 1, The individual is free from the control and direction of the hiring entity. Now, I want you to just think through this hypothetically. This is where I think there is a lot of unknowns, but there is a lot to be aware of, and there's a lot to plan ahead for. Okay? If an AMC, for example, again, these are all hypotheticals at this point because this law is fairly new. But if an AMC says, okay, I need you to go out and do this inspection on this particular day, are you truly free from the control and direction of the hiring entity? If the AMC says we don't want you to wear shorts and flip-flops, okay, no brainer to me, but if they say that, are you truly free from the control and direction of the hiring entity? If the AMC comes back and says, I don't like comp number 3, take it out, are you free from the control and direction of the hiring entity? If the AMC says, I want you to follow Fannie Mae guidelines. Yeah, I know. Are you truly free from the control and direction of the hiring entity? If any direction at all is given, are you truly free from the control and direction of the hiring entity? This is a big deal, folks. And by the way, this is not proposed legislation. This is law in the great state of California. So that's from an appraiser standpoint. Okay. Do you need to be worried about that? I don't know. But I'll tell you, I sure do a lot of work for a lot of AMCs, a lot of clients, and some of them are located in the state of California. In fact, I just picked up a client just before the New Year's. A new client called me up out of the state of California, does a lot of investment work in Idaho. Okay. First of all, is it my responsibility to know where they're calling from? Second of all, how much trouble can I get in with this new legislation? Now, again, this is from the contractor or the employee position. After the break, I want to take you to the more scary side from the employer's position. I want to pause here, of course, to remind you that we are sponsored by 3 great companies. Number one of them being a la mode. A la mode is number one. Number one in software for appraisers across the nation, have been for years and years and years. There's a reason for that, folks. The reason is they care about appraisers. They want you to succeed because if you succeed, guess what? They succeed. Therefore, they are constantly putting out new tools that will allow you to be more efficient, more effective at what you do. Check them out. Go to alamode.com or call them at 800-ALAMODE. Another company, great company, that uses the first leg of the stool that I talked about earlier, and that's technology. Technology to be able to allow you to be more efficient, more effective at what you do is, well, DataMaster. DataMaster is out there helping appraisers to do data entry and save you time and energy. How much time, Dustin? That's right, folks. About 45 minutes per report, between 30 to 60 minutes per report. I've timed it. It's not just a motto. It works. Check them out. Go to datamasterusa.com. Again, it's datamasterusa.com. Finally, we are sponsored by Working RE Magazine. What does Working RE stand for, I've been asked? Well, it stands for Working Real Estate. And the reason for that, when it doesn't say Working Appraiser, which it could, by the way, most of their focus is on appraisers, but they also focus a little bit on home inspectors as well. Okay, so they're called Working RE Magazine, but their focus is helping you to know what's going on in the appraisal world. And by the way, their information is free. Check it out. Go to workingre.com and sign up for their free newsletter. It's workingre.com, workingre.com. Welcome back to the program, folks. We're talking about Assembly Bill number 5, which is now a law in the state of California. And basically the law says there's an ABC test that you must take in order to, well, we've looked at it from the employee standpoint. Let's now look at it from the employer's standpoint. So as an employer, let's just go strictly with the state of California. Let's say I'm located in Sacramento, California, and I want to hire somebody and I want to hire a contractor. Okay. The only way I can do that now, as of January 1, 2020, in the state of California, is to make sure that the individual that I hire and I call a contractor, a W-9, must meet all three of the following tests. Number one, I cannot control or direct them. Number 2, they must perform work outside of me. And number 3, they must be regularly engaged in that kind of industry or work on a regular basis. Okay, so for those of you who live in the state of California and you have individual contractors and they are not doing work for other appraisers, you may want to take a second look. For those of you who live in the state of California and you've hired independent contractors and you ask them to do and to perform in a certain manner, you may want to reconsider. For those of you who have hired in the state of California, you call them individual contractors, and they are not regularly involved in a business that is in the same industry as you may want to take another look. Now, Dustin, again, I don't live in the state of California. From an employer's perspective, why is this a big deal? Well, they say, as goes California, thus goes the nation. I don't know how true that is in reality, but I certainly have seen it in the past. Right? I don't know whether this will catch on across the country, but I'm not thinking it won't. Now, again, the IRS for years has been fighting against the contractor thing because it means more money in their pocket. They don't like it. Now, I'm very comfortable with the contractor thing. I have both employees and contractors, and I've made damn sure that my contractors meet the tests that they need to meet in order to be called a contractor. For example, I have a contractor right now who helps me with some data entry and even a little bit of analysis, right? She has a business name. She works for about 3 other appraisers, maybe 2 other appraisers other than myself. I don't direct her. She's very, very independent in as far as what she can do, what she can't do, okay? And I know that going into it. I know that she's not my employee. I have very little control over what she does and how she does it. And to me, that's the trade-off, and that's why I can with confidence, call her a contractor. Even in the state of California, even reading the memo, I would be confident that this individual meets those criteria. Okay? On the other hand, is it worth the risk? Again, do I want to be the guinea pig for this type of legislation? Yeah, that was a rhetorical question. The answer is no, I don't. And here's the thing. Appraisers, do you want to be the guinea pig as well? Now, you may not be located in California, but you still have IRS regulations that you should be paying attention to and that may affect you. Here's what happens, folks. If you hire an individual, and this is in the state of California, this is in the state of Nebraska, it doesn't matter. If you hire an individual and you call them a W-9 contractor, and you get audited 3 years later, and the IRS, for whatever reason, determines that that person is not a contractor, okay, you got 3 problems and potentially 4 problems on your hand. Number 1, you got back taxes, because there's taxes that you have not paid because that was passed on to the contractor. Number 2, you got penalties for not paying those taxes. Number 3, you've got interest for not paying those taxes. And number 4, you may have criminal problems as well for eluding taxes. Now, I don't know whether the IRS would take it that far or not, but is it worth the risk? Now, from a business perspective, and I'm going to put on my appraiser coach hat for just a second. I used to be a big advocate for contractors, but I changed my tune several years ago. And I changed my tune for a variety of different reasons, but one of them was simply economics. When you look at it in black and white, and I love numbers for this reason, because math doesn't lie. In the state of Idaho, and it may be a little bit different where you're at, depending on what types of tax structures you have, but I doubt it's much different. But in the state of Idaho, the difference between an employee and a contractor is about 7%. Okay? So for every $100 that I pay a contractor, to have them as an employee, it would cost me $107. Now, is that $7 worth the risk of utilizing a contractor? I don't know. Again, I'm not going to make that decision for you, but I will say from my perspective, I have a whole lot more employees now, which is the exact opposite 180-degree turn from where I was previously. I used to be a big employer on contractors, and now I'm a big employer of employees, of W-4 employees. And one of the reasons is the control, frankly. You know, It's the ability to be able to say, hey, Joan, I need you at the staff meeting on Monday at noon. Hey, John, I need you to go out and do this appointment at 3 o'clock on Friday. I like to have that ability because it helps me to run a tighter ship. So from the aspect of an employer, okay, it just got much, much harder to employ contractors in the state of California. Will that spread across the nation? Yet to be seen. What happens when you don't comply? I don't want to be the guinea pig to find out. Okay, but even from an appraiser's perspective, you need to be aware of this law. All you got to do is jump on Google, okay, type in new California contractor law. I guarantee it'll pop up, okay? Just make sure you're reading the right stuff. It'll be the law that went into effect on January 1, 2020, or just type in Assembly Bill 5 or AB 5 California, and there's plenty of reading materials there. Thank you for joining me today, folks. I really, really appreciate each and every one of the minutes out of your life that you spend with me. I really appreciate the opportunity to talk into this microphone and hope that it's doing some good in your life. Speaking of doing good in your life, would love for the opportunity to help you in any aspect I can. Please reach out to me. Go to theappraisercoach.com, sign up for the All-Star team, and start getting a ton of great information on how you can be more effective as a real estate appraiser. We'll catch you next time.
You've been listening to the Appraiser Coach podcast with Dustin Harris. If you like what you hear, please give us a 5-star rating and post a short review on iTunes. For more in-depth insider information on how you can make more money as a real estate appraiser, visit theappraisercoach.com and sign up for the All-Star team today. Thanks for joining us. And now, get out there and create some value.